So last week, I worked on a request for further evidence, otherwise known as an RFE, for an O1B extraordinary ability petition that I filed for one of my clients who is an artist. The RFE was 9 pages long, and when I first received it in the mail, my heart sank. Immediately I was dreading having to deal with it. And I would say after filing the response, I feel really confident. Of course, nothing can ever be a guarantee with immigration, but I just have a feeling in my gut that USCIS will approve my client's O1B petition. So, what are some tips about how to respond to an RFE? I'll just walk you through my thought process and how I strategized my response to this particular RFE. First of all, don't get immediately freaked out if you have an RFE that's many pages long. When I kind of read my RFE a few times, I didn't really formulate my entire strategy until kind of really letting it digest for a while. Sometimes when you read something for the first time, you miss a lot of details, right? But the more I read the RFE, the more I realized, what immigration is saying here doesn't really make sense, or what immigration is saying here is internally consistent with something else that they're saying. So that's how I kind of put together my strategy for responding to all of immigration's allegations on the RFE. First of all, I told myself that even though the RFE was 9 pages long, most of it was just immigration quoting from the statute, right? And also immigration quoting from the testimonial letters that my client had obtained from experts in the industry. So that was a lot of filler. Secondly, another thing immigration loves to do when they issue RFEs is that they'll use a boilerplate or a template that doesn't really speak to your particular case or your client's case. So it could seem initially daunting to get a thick envelope in the mail and you're thinking, this is like a really harsh RFE. How am I ever going to overcome whatever immigration is raising? But after I saw that immigration was mostly quoting from the statute, they also threw in all of the criteria for O1B. Even though, we only argued three, they decided to throw in all six criteria, right? And then they kind of went out of their way to say, well, you did not request or claim this criteria. However, if you still want to submit evidence, you can. Well, why would they do that, right? I already know what the criteria are. So after I was able to kind of realize that the substance of the RFE was not 9 pages long, then I was able to kind of feel, okay, I have a handle on this. I know how to address whatever immigration claims are shortcomings. So one tip is read it several times. You're going to catch things that you didn't initially, notice from the beginning. Secondly, think logically about immigration's arguments. Do they even make sense? So in this particular case, immigration said that my client met one of the criteria, which is proving that he had demonstrated that he had national and international acclaim as an artist, right? Yet somewhere else on the RFE, they said something that was totally inconsistent. They said that the testimonials that my client submitted from experts did not prove that he had reached this level of national or international acclaim. Well, how can immigration say both at the same time? That means that they have to be wrong. So that was one of my arguments. There was no way that immigration could agree that my client was internationally or nationally well known as an artist, and then on the other hand say that he wasn't. Another thing immigration said was that the people who submitted testimonials for my client didn't appear to be experts, and that we did not explain why these individuals should be considered to be experts. So I went back and I reviewed the testimonials. Sure enough, every single of the testimonials, the very first part of their letters spelled out why they were experts. Some of them were examples including, I am routinely hired as a consultant, right, to give my expert opinion on pieces of art. Well, clearly, each of the authors had gone out of their way to explain all of their years of experience, their expertise, positions that they have held, whether they be professors, whether they be curators, artists in their own right. Some of them also had published books, written articles. So that was how I attacked immigration's point. right? That the testimonial letters were not experts, therefore their opinion doesn't matter to immigration. Well, I said in my response to immigration, the only way that you could have come to this conclusion that the authors were not experts is if you completely ignored the evidence that we submitted, right? Another point I like to make to immigration is that they cannot pick and choose what evidence to focus on. Immigration is not allowed to cherry pick evidence, focusing only on what they consider to be weak points. They have to take all of the evidence that you submit in their totality, right? They cannot conveniently ignore evidence which tends to prove your client's eligibility. Another tip is, what is the burden of proof that clients have to establish? Say that want to apply for an O1 visa. The burden of proof that immigration has to apply is called preponderance of the evidence. What does this mean? So it basically means that if the reasonable person, upon reviewing the evidence, would come to the conclusion that you qualify for whatever immigration benefit you are seeking, that there is 51% or more likelihood that you have proven your case by submitting the evidence, right? It's not beyond a reasonable doubt. It's not by clear and convincing evidence. This is what immigration officers seem to do, is they conveniently forget, right, that they are only supposed to apply a preponderance of the evidence standard. So this is something that I almost always throw in towards the end of my response, is to remind officers, you cannot create new law, right? You cannot create new standards of burden of proof. I also remind officers that they have to review all of the evidence submitted. They can't just selectively consider evidence that they believe to be weak while meanwhile ignoring other parts of the evidence. One last thing that I have is to give as advice is read the RFE carefully, because believe it or not, immigration will misinterpret or mischaracterize evidence that you submit. Whether or not they're doing it intentionally or not doesn't even matter. I don't know what's worse. If it's unintentional, then that means the officer doesn't really know what they're doing. If it's intentional, then it means the officer is biased, right? And you can call immigration out for that as well. The USCIS policy manual clearly instructs officers that they have to review cases fairly, right? They cannot be biased. Secondly, don't let immigration distort what is in your record, what you submitted, right? Just because they claim that evidence is X doesn't necessarily mean it's true. Go back and review your file. A lot of the time, I've caught immigration making mistakes and mischaracterizing evidence. That was another argument that I used in my request for evidence. So I hope these tips are helpful. If you're dealing with an RFE, you're not sure if you're handling it properly, I'm more than happy to help, to review. If you don't have an attorney, I'm also happy to step in, provided that there's enough time to respond to the RFE. Don't contact me the day before the deadline is due, because I'm not a magician. But my information is below. If you would like my help, feel free to reach out to me, and I'm happy to take a look at your case.